So we continue to look at the case of Horace Richards versus Geraldine Ramsay-Facey. Mr. Richards' stepfather, who is also Mrs. Ramsay-Facey's brother, had died. Mr. Richards said that the deceased left him a will, but Mrs. Ramsay-Facey had obtained a letter of administration, and it said that there could be no valid will because she would have known about it. Okay, so they're facing each other in court here over those claims as to who should get his estate, who should be the administrator of his estate. So we continue by looking at the analysis and discussion. In examining the application, I took special notes. As the judge, I took special note to the provisions of Section 4 of the Act, which reads as follows. Section 4, subsection 1. The residency estate of an interstate shall be distributed in the manner or held on the trust specified in the following table of distribution. Table of distribution. Item 4. Other eligible relatives. 1. If the interstate leaves, that means somebody dies without leaving a will, leave no surviving spouse, issue, or parent, the residency estate shall dissolve or devolve on the other relatives entitled under this item who survive the interstate in the following order and manner, namely, firstly, to be held under the statutory trust for the brothers and sisters of the whole blood of the interstate. But if no person takes an absolutely vested interest under such trust, then, secondly, be held under the statutory trust for the brothers and sisters of the half-blood of the estate. So first of all, the first person in line to get the estate are the brother and sister, where they have the same father and the same mother. Second in line would be the brothers and sisters, where they have the same father but not the same mother, or the same mother but not the same father. That would be the half-blood. So secondly, to be held under the statutory trust for the brothers and sisters of the half-blood of the estate. But if no person takes an absolutely vested interest under such trust, emphasis added. Okay. So now, here, the affidavit of Mrs. Ramsay-Facey, as well as her oath on administrator, both outlined that Everald Ramsay had been her sibling. As such, she would properly fall within the category of individuals outlined in item 4.1. So she would be a brother. She would be the sister of Everald Ramsay. Part 1A, which would have been entitled to make an application for a grant. So she, being the sister, would entitle her to make a grant of administration. At the time when the application had been made, Mabel Ramsay, who passed away, and the claimant, that's Mabel Ramsay's son, would not have been qualified to apply, as he was not an issue or lawful descendant of Everald Ramsay. The issue which arises for consideration could be described as two sides of the same coin. As a determination has to be made whether the purported will satisfies the requirement of the Wills Act in order to justify the revocation of the grant. In coming to this conclusion, it was also necessary to decide whether the evidence presented by the defendant reveals that the document is in fact fraudulent and should be rejected by the court. The relevant requirements to establish the validity of a will are outlined as at Section 6 of the Wills Act, which states as follows. All right. We're looking at what makes a valid will or an invalid will. No will shall be valid unless it shall be in writing and executed in manner hereinafter mentioned. That is to say, it shall be signed at the foot or end thereof by the testator or by some other person in his presence and by his direction, and such signature shall be made or acknowledged by the testator in the presence of two or more witnesses present at the same time. In such witnesses shall attest and subscribe the will in the presence of the testator, but no form of attestation shall be necessary. No form of attestation shall be necessary. So the will is to be signed by the testator, the person making the will. Or if that person cannot sign it, maybe they lost their hands, or their hands have been so injured, they assign somebody to sign it on their behalf, and must be signed in the presence of two witnesses who must be there at the same time and also sign it. All right. Every will shall, so far, only as regards the position of the signature of the testator or of the person signing for him, as aforesaid, be deemed to be valid within this act if the signature shall be so placed at or after or following or under or beside or opposite to the end of the will, that it shall be apparent on the face of the will that the testator intended to give effect by such his signature to the writing signed as his will, but no signature under this act shall be operative to give effect to any disposition or direction which is underneath. Let me read that part again. But no signature under this act shall be operative to give effect to any disposition or direction which is underneath or which follows it, nor shall it give effect any disposition or direction inserted after the signature shall be made. All right. Now, in the local authority of Reginald Ramsay versus Linton Ramsay and others in 1989, which dealt with an application to declare a will invalid, Edwards J. outlined the following legal principles. Where a will contains a proper attestation clause, there is a presumption of due execution of the will. This presumption can be rebutted by evidence of the attesting witnesses or otherwise. Attestation means that the document is executed in the presence of a witness by who signs by way of attesting the execution. A will can be proved by calling at least one of the attesting witnesses. Okay. Although the law is that the signature of the testator must be made or acknowledged in the presence of two witnesses, and the witnesses must attest and subscribe the will in the presence of the testator, it is not essential for the attesting witnesses to sign in the presence of each other, although it is usual to do so. Okay. They don't necessarily have to sign in the presence of each other. Each witness must be able to say with truth that he has seen the testator sign the document, though it is not necessary that he should know that it is the testator's will. Okay, so the witness who signed it is only signing to say that they see that person signed the document, but they don't have to know what it is that they signed. Okay. There is no sufficient acknowledgement unless the witness either saw or had the opportunity of seeing the signature. Applying these principles to the circumstances before me, I note that there is evidence of a proper attestation clause on the face of the purported will. Additionally, there is a joint affidavit from the attesting witnesses in which they outlined witnessing the testator signed the document which they knew was for a fact was his will. They knew for a fact was his will. Ordinarily, this would have been sufficient to raise the presumption that the will was properly executed. It was noted by Edwards J., however, that his presumption can be rebutted by an attesting witness or other evidence, and in this regard, the defendant had sought to rely on her assertions of the physical and mental decline of the deceased. Okay, so this raise a presumption. Okay, there's the presumption that the will was properly executed, but this presumption can be rebutted by other witness who testify that the person who said they signed the will, who supposedly signed the will, was not of proper mental capacity to sign a will. All right, so that's what Mrs. Ramsay-Facey is trying to do here. In asserting this evidence, I note that no medical evidence had been presented in support of this alleged incapacity. All right. So what this seems to be saying and suggesting here now is that if your elderly relative is going to sign the will leaving the estate to you, and that relative is sick, in bed or something, maybe in a wheelchair, whatever the case is, spend the money to get a doctor to examine that person's mental capacity to sign a will. Let the doctor sign the document and you keep it, and then the person sign the will. Because a relative might take you to court later on and say that so and so could not have signed a will because that person was not of proper mental, in a proper mental state to sign a will, so that will is not valid. So you have evidence, you would have evidence to present that doctor said that this person was in a proper mental state to sign a will. Alright? So make sure you do that. You have an elderly relative. When they sign the will, get a doctor to examine them to state that they are of proper mental capacity. Alright. So, in assessing this evidence, I note that no medical evidence had been presented in support of this alleged incapacity. This was of great significance in the circumstances where Mr. Martin, his alleged caregiver, was not able to provide the name of the individual who she asserted had been the deceased attending physician. Oh. Well, of course. Oh, let me also say, if you are contesting, or if you see your elder relative going to sign a will and you're contesting whether that person is capable of signing a will, then it's important that you get a medical doctor to attest whether that person is really mentally capable of signing a will. Alright? So here now. Additionally, there was no evidence provided whether by her, that's Mrs. Ramsay-Facey, or the defendant. No evidence provided whether by her or the defendant explaining the defendant is Mrs. Ramsay-Facey, explaining the absence of a medical report in respect of Mr. Ramsay. Where is the medical report? You see that? The judge is asking for the medical report. You say Mr. Ramsay was not mentally capable of signing a will. Where is the medical report to prove it? In spite of the passage of time, I did not believe that it would have been unexpected or unreasonable for such evidence to be presented in order to rebut the veracity of the affidavit of due execution. Right? So, even though time has passed, they could still have gone to the doctor or the hospital to get the medical records to state whether Mr. Ramsay was medically capable of signing a will at the time he signed it. Alright? While I recognize that the claimant, Mr. Horace Richards, bear the burden of proving his claim, I also had a number of questions in respect of the reliability of the defendant's, Mrs. Ramsay-Facey's, evidence. I note that her affidavits were contradicted in several material respects by the content of her oath. She asserted in her affidavit that it was not true that the deceased had made a will. Right? And she highlighted that there was no need for him to do so, as he owned no assets and had been a man of impetuous means. Impecunious. Impecunious. My first I remember seeing this word. I just looked it up online. It says having little or no money. My. Impecunious. I have to make a note of this word. New word to me. Impecunious. A man of impecunious means who had to be assisted by her. At paragraph 15 of her oath, which was filed on the 11th of April 2012, she stated that although the deceased had died leaving no personally, he had left realty which was valued at Jamaican $1 million and had a gross value of Jamaican $100,000. But she said he had no assets. Interesting. In her supplemental oath filed on the 1st of May 2013 in addressing a requisition whether there were any possible beneficiaries under the estate intestacy of her brother. She stated at paragraph 5 that the deceased was survived by his wife Mabel Ramsay, who died on the 27th of April 2009, leaving no issue or other beneficiaries. Well, no. This assertion was clearly not true, as she was always aware of this claimant, of Mr. Richard. So Mrs. Ramsay claimed in her affidavit that her brother died leaving a wife and no other relative. But the fact is, she knew that that wife had a son. So that claim was not true. Maybe he was not a blood relative, but legally he would have an interest in his estate. Alright. In circumstances where she had raised questions in respect of the material and physical capability of the deceased, with no medical evidence to support this. You see that? With what? No medical evidence to support this. You better get medical evidence, get document that you can present in court. With no medical evidence to support this, it is arguable that this was done purely to prevent the claimant, Mr. Horace Richard, to prevent him from obtaining an interest in the property. That's the only reason why she did it. Additionally, the veracity of her assertions in respect of the health of Eva Ramsay had been greatly undermined by contents of the document provided by her. So her assertions could not be verified based on those documents that she presented. Her documents presented are contrary to the words that she's using, to her claims, verbal claims. I have considered whether her case can be rehabilitated by the evidence of Miss Doreen Martin, a witness who, it must be acknowledged, has a benefit to gain if the grant were to be upheld. So remember now, Miss Doreen Martin is the niece of Miss Ramsay-Facey. And Miss Martin would certainly have something to gain. Now, Mrs. Ramsay-Facey had so far been losing this case, presenting contrary evidence. Can she be helped by Miss Martin, her niece? Let's see. I have considered whether her case can be rehabilitated by the evidence of Miss Doreen Martin, a witness who, it must be acknowledged, has a benefit to gain if the grant were to be upheld. I carefully considered the account of Miss Martin, and I was also left with a number of unanswered questions. Oh, my. It was Miss Martin's evidence that she had moved in with her uncle in order to care for him. This was refuted by Mr. Richards, who asserted that there was no need for any such arrangement as his mother was present in the home and in a position to care for his stepfather. It was never denied by Miss Martin or the defendant that Mabel Ramsay lived with her husband until his passing. Okay, so Mr. Richard's mother had always been taking care of the deceased up to his passing. Neither was it denied that she was capable of taking care of him and was in fact the person who did so. So that went without any opposition. Alright? That Mr. Ramsay's mother, Mr. Richard's mother, was taking care of the deceased, of Mr. Ramsay, before he died. There was no evidence provided by Miss Martin which explained why she was called on to play this role. How was she paid? Who paid her? By whom and how she was, by whom or how she was able to afford the care and medication needed for such a gravely ill individual? Well, no. Questions. In determining what weight to give to her account, I found that it lacked credibility and failed to provide the critical support needed in respect of the defendant's case. Well, no. In the text Parry and Carnegie, Carriage, the Law of Succession, 12th edition, at page 466 to 467, it was noted that a grant of administration may be revoked if it was wrongly made, or a will is discovered after the grant. It was also noted that a grant is wrongly made if it was obtained as a result of false statement by the grantee, whether made false fraudulently or in ignorance of the truth. Having received the evidence in this matter, it is clear that there are representations made by the defendant. It is clear that there were representations made by the defendant, as Mrs. Ramsay-Facey, which were untrue. This in and of itself provides a proper basis for the revocation of the grant. In the instant matter, there is a purported will in which the deceased had sought to dispose of his estate. Having reviewed the will, the evidence of the attesting witness, so you see, will is put in quotation mark because it is being questioned. The evidence of the attesting witnesses and the claimant himself, Mr. Horace Richards himself, I am satisfied on a balance of probabilities that the document satisfies Section 6 of the Wills Act, as will has the established legal principles. Accordingly, I make the following orders. A. The grant of administration made in the estate of Everard Ramsay on the 21st of October 2016 is revoked forthwith. So you can see that Mrs. Ramsay-Facey and her niece are losing this case. They have lost the case. You can see it from here. B. The reversal / setting aside of any action and or acquisition done and or taken by the defendant in contravention of the diverse will under the will is reversed and set aside with immediate effect. Costs are awarded to the claimant, Mr. Horace Richards, to be taxed if not agreed. Claimant's attorney, Mr. Richards' attorney, to prepare a file and serve the order therein. So, there you have it. Mrs. Ramsay has lost this case. Remember to subscribe to this channel and let us discuss this case in the comment section.